Mitchell.
Chair, I rise on behalf of New Zealand First to take a call on Part 2 of the Employment Standards legislation bill. And I just want to start my contribution by saying there has been a large number of fantastic contributions tonight in the House. I do have to say I had a smile on my face on the news tonight with regards to the Maori Party, Labor and the National Party all trying to take credit for fixing this problem up. And in actual fact, credit really needs to go to the people of New Zealand who have clearly stated that they actually want zero-hour contracts removed from legislation and not to have them legitimised. So well done, New Zealand. Well done for speaking up. I would also like to take the opportunity to thank a number of the people from the NZCTU that have worked with New Zealand First, along with some of the other parties, to come up with better ways of addressing some of these problems, particularly around zero-hour contracts, Mr Chair. Mr Chair, I have to say that just finishing off with what Ms Sue Moroney has just been speaking about one of the submitters that came into the House and into the chambers to talk to us about her concerns, and it wasn't actually 100% correct what Sue was saying. It was, Ms Moroney I should say, it was actually a casual employment contract that she was on, but was turned into a zero-hour contract. She was actually basically in a casual employment agreement with a law firm. She found herself exposed to being vulnerable as a very intelligent woman who was a solo mother looking after her young people, that there was no guaranteed number of hours, and she was pretty much just casual as and when required. And it just shows the vulnerability of even our educated sector, because we stereotype people that if they're vulnerable, they've got to be uneducated or they've got to have low-earning jobs. But that's not the case. And so my question, Mr Woodhouse, if we could indulge you to stand up and take a call on this, I would very much appreciate it, is what are we going to do about the people that are vulnerable under casual employment agreement? Because we understand in a modern-day workplace the importance of having casual agreements. We understand part-time and we understand full-time, and we've heard the commendable result in today's discussion with regards to the outcome of getting rid of zero-hour work contracts. And so to that end, New Zealand First is in a position of support, so that's changed from where we've come from. But we are still very concerned about the involvement of casual employees being exploited, not through zero-hour availability clauses, but through just being sort of as and when needed and as required. And as we step into Part 3, I would urge you to take a look at the supplementary order paper put through by New Zealand First with regards to that, because we believe that that will clear that up. We have support from Labor. It's been given to me today that they'll be supporting it. The Greens will certainly support it, and we would love to see support of that because it's very important. We'll get to that in a moment. But if you could explain what the steps that the government are going to take to indemnify, if you will, those vulnerable workers under casual employment agreements. I couldn't speak more positively than this change, this much-needed change in our working environment, sir. I think we have seen over the years a direction getting towards being a better working place where there is a balance from workers and bosses, employers and employees, whichever way you want to say that. And a real balance of relationship, in any relationship, whether it be a personal relationship, a sporting relationship, or one with a friend, but certainly an employment agreement, is when both parties have equal power. And I think what this employment agreement does is actually restores the balance of power for the employees, to empower them to be able to stand up and rightfully say, this isn't fair, I'm not happy about that. Which takes me into some other parts of the bill, because I don't want to redress what has already been strongly spoken about, is the removal of those zero-hour contracts. But what I do also think is Part 2 has got some very, very positive aspects, is the inspectors and the individuals now have the power to enforce. And once it was just down to the Labor inspectors, now individuals can actually take umbrance and take action towards an employer if they feel like there has been some injustice or an imbalance in their agreements. I think the higher penalties that have been put forward is another huge incentive for employers to act more responsibly in their working environments towards their employees. Those penalties now going for an individual up to $50,000, Mr Chair. Mr Chair, thank you, sir. And for a body corporate up to $100,000 or 3 times the amount of money that has actually been sought or lost by the employee, sir. I think those are certainly some good punitive penalties coming through there. We've got declarations of breaches on page 48 on part 2 and compensation orders made by the court. And what I like to see of these banning orders that have been brought into part 2, sir, with some very, very hefty penalties of $200,000 if there has been a breakdown and a continual abuse of these parts. The parts around the requirements to keep records, I think, is very, very important, and I do actually look to the Greens in support of their supplementary order paper with regards to that, because even salaried workers can find themselves in a position where they do a little bit extra here and they do a little bit extra there, and all of a sudden it becomes normalised. It becomes just what I've always been doing. And so salaried workers, there is a potential loophole there for them not keeping a record of the hours that they work where the employer could actually take advantage of them. And so we do support the fact that all records of employees should be kept and should be available for scrutiny to make sure that there isn't a disadvantage by anybody, salaried or otherwise, sir. It's not an onerous expectation. I like also the fact that there is no ability to indemnify the employer by insurance to let them get away with malpractice of employment. And I think, as opposed to parts of the Health and Safety Reform Bill which didn't allow this to happen, this is a completely different situation where I think it is necessary to take that availability away from the employer to indemnify themselves with insurance. Again, another part of part 2 which I think speaks very, very strongly of the new direction is the ability or the inability for employers to take unlawful deductions from employees. We've heard many, many cases where staff have had deductions taken, whether it be a restaurant worker with a table doing a runner, or whether it be a fuel station worker or a petroleum dispenser, as they like to be referred to, sir, where somebody has run off without paying, and then those deductions being taken away from their wages are unreasonable, and certainly this new piece of legislation addresses that. I would also like to say, to wrap up my contribution, part 2 shows some very, very positive changes. It has certainly been a long time coming, sir, and we look forward to part 3 and a contribution from the Chair, from the Minister himself with regards to casual employment and how that is going to be minimised, any exploitation of those workers. Thank you, sir.
David Clark.